and all that the speaker or the deputy speaker for that matter said, and I want to quote verbatim. The relevant.
Quoting which answer, which page, which paragraph?
The answer of 29th November, page 6,445. Just want to quote the directive given to the committee verbatim, that as per Rule 175 of our Rules of Procedure, I refer Honorable Zaake to the Committee on Rules, Privileges, and Discipline for disciplinary action. But what preceded that directive is the expression of the speaker about the proceedings. And in the interest of time, I may not have the luxury of going through what the speaker said, but it is there, captured on the Hansard, Mr. Chair and honorable members. The speaker does not talk about misconduct or misbehavior. So, and nowhere in this record it is mentioned. So our client is at a loss as to where this allegation is coming from, Mr. Chairman, which is captured on the head note of the summons, that there are allegations made against him about that particular accusation. Two, I think those allegations is also not mentioned, because that would help us also prepare our case. Who is accusing him of misconduct or misbehavior? The particulars of that individual are not disclosed, because that would help us also dig into what could be the motive of the person making the allegations. As you know that, Mr. Chairman and honorable members, because motive in matters of this nature is important to get to understand why would one make allegations, and it would help us in cross-examination and dealing with those matters. The third issue, also related to that, even if it were to be construed from the statement of the speaker that may be intended to accuse the Honorable Zaake of misconduct or misbehavior, if it's by construction, if we were to stretch it to that extent, that maybe by construction, that's what he meant. Again, Mr. Chairman, there are no particulars. What is it that the Honorable Zaake did which constitute the impound act of misconduct or misbehavior? What is it that, because it will help us again prepare. Because I don't want to bring in the practice in courts, but it's analogous to that. That once there is an accusation against you, it has to be particularized that you are accused of misconduct or misbehavior in that you did A, B, C, D, contrary to the law or practice or given set of conduct or rules. Again, we find it nowhere that the allegations are particularized. What is it? What is that act, the impound act that the Honorable Zaake allegedly did on that fateful day? It's not known to us. We have tried to scan through the record here. All we are seeing proceedings, Honorable Zaake, sit, no, what, nothing like any act. And finally, Mr. Chair, the proceedings already on record. We have issues with that. The recordings that were tendered in and the transcriptions made, as well as the analysis made by one Paul Kato, we ought to have been present to cross-examine them. Because, Mr. Chair, as indicated in the first notice, the Honorable Zaake, that is the one of 7th December, 2022, the Honorable Zaake was required to be here. On the second sitting, Wednesday 14th, that's when he was required to be here. Wednesday the 14th of December. But the committee received evidence or witnesses on 13th of December in his absence. Yet, Mr. Chair, as you correctly observed from the record and from some of the communications made, he reserved the right to cross-examine those particular individuals. I wouldn't want to call them witnesses, but those individuals who appeared here to tender in that recording to substantiate some of the allegations they were making, which we have looked at here, and we take exception of the same. To be exact, Mr. Chair, there is one Pokato who made a conclusion that has really disturbed us. That actually in his conclusion, the conduct of Honorable Zaake was violent, picking it from nowhere.
Let's not go to the substance, let's look at the preliminary matters.
Those are the preliminary matters we intended to raise, which make it extremely difficult for us to proceed with the case. Actually, we couldn't sit and prepare a defense under those circumstances where you lack sufficient information, you have no particulars, you don't know who is making the allegations, and those allegations are not substantiated. That made it difficult for us to prepare any meaningful response to the same. I thank you, Mr. Chair. And finally, Mr. Chair, when you look at Rule 175, under which this matter was brought, we presume that it was maybe brought under sub-rule 1B, because the speaker was not so specific. Just said under Rule 175, but there is sub-rule 1A, B, C, D, E. We are again at a loss as to which particular sub-rule we are proceeding, or the entire rule. But it became a little difficult for us to ground it on any of these particular rules. I will substantiate on that later, Mr. Chairman. I thank you.
Okay, colleagues, issues of a preliminary nature. Let us dispose of those which I think don't need a lot of mind to address ourselves to. One, about cross-examination. In our communication to the Honorable Zaake, we did reiterate in writing that he has a right to cross-examine anybody who will appear before us. We always are aware of that, and that we always implement. So nobody should complain about cross-examination. Any person you would like who appeared before us and you would like to cross-examine him, you will always cross if you so wish. But at the same time, we can't force anybody to cross-examine. If you come, you cross-examine. If you don't, then there's nothing we can do about it. So, about your right to cross-examine, that is guaranteed. And we did communicate that in writing. I think maybe, can I have my colleagues intervene at this point before for the colleagues who just walked in, the Honorable Lukwago is raising an issue that he has read and it doesn't show anybody complaining of misconduct. And then two, he's saying that the communication to his client does not give particulars of the misconduct. I hope I've got you correct clearly. Those are the two issues you're raising.
Yes.
Correct?
Yes.
Yes, he agrees with those. So those are the two issues he's raising in a summary. Do you have anything to say before I can see how I can guide?
if counsel thought he needed this before, he would have written to the committee asking for some of these things. Okay? And to me, whether there is a complaint undisclosed or not at this stage, that should not stop us from proceeding. The issue of particulars of the misconduct, Chair, you have always, I think, guided on this matter, that we are not sitting as a court, we are not prosecuting, we are not doing this and the other. All those particulars you're talking about, as we call witnesses, as we are inquiring, the witnesses appear before us, and you pick what you talk as particulars, because here we don't have a charge sheet where we expect to have the particulars of the offense. If at all there is any offense, we are dealing with disciplinary matters here. So, Chair, in my view, I think my land friends' preliminary issues, in my view, weak, and we can proceed. And then he will, as we are proceeding, we'll be in a position to know the nature of the complaint. If he has not understood it, then when someone is testifying, perhaps we'll be in a position to understand what the complaint is about. But having read through what transpired on that day, I think anyone will be in a position to understand. And then Counsel was also raising the issue of speaker not being specific on which particular paragraph we are proceeding. Again, when you look at the proceedings, you'll be in a position to know as a lawyer whether this is under 1A, other B. I think it will be too much on our side to begin particularizing that we are proceeding under this and the other. But as we proceed, we'll be in a position to know where we are, because this was referred to the committee by the House as a matter concerning discipline, and we are mandated to look at those matters. Chair, that is my view.
Anybody who has anything to say? Any investigative body. The Honorable Zaake is not on trial here in terms of a criminal prosecution, where there is a prosecutor with a charge sheet and we are seated as a court. The nature of this parliamentary committee is to investigate whether there is any act that offends the rules, that offends our code of conduct. So we are actually investigating it. And as you realize, nobody is prosecuting here. We are just listening to the evidence we have. Having said that, I think it is also maybe not correct if you just look for the word misconduct. You need to read the entire Hansard and see the communication of the speaker before he arrived at the decision of referring this matter to us in Rule 175, what had transpired. Because if you are looking just for the word misconduct, you may not get it. But when you read the Hansard, there are complaints, there is a dissatisfaction. And our committee is now supposed to investigate whether that results into a misconduct or not, whether it offends our code of conduct or not. So don't just look for the word misconduct, you'll not get it. But when you read the entire Hansard, the communication, you'll find that there is a complaint arising out of an alleged, and I repeat, an alleged action of the Honorable Zaake. We don't know until we have the evidence. But this is the good news, that nobody is going to come here and allege anything except with your right to cross-examine. Whoever alleges will come here, present his evidence. And if that evidence, in our opinion, amounts to misconduct, then we'll put it to the Honorable Zaake. And in our communication, Counsel, we had said that he's entitled to attend all the proceedings. Even if you want a recall of any witness, we'll recall any witness, so that you're really aware of the facts we have and the decision we are going to make. So there is no ambush, I want to comfort you. We will not ambush because we have no personal interest in this matter. Absolutely none. And, you know, this process is a peer review mechanism. It's about us, how we behave, whether we behave in accordance with our rules. That is all. So I don't want you or the public to have an impression that we are now seated and we are prosecuting somebody. The rules don't give us those powers, but they give us powers to investigate. Your reference to Rule 175, this matter has already been resolved. The powers of this committee. Actually, the Honorable Zaake helped us so much to take this matter to court in the other case. Now we know the powers the committee has because the Constitutional Court was very clear on the powers this committee has. And as you realize, because you are representing him, the Constitutional Court upheld our report and it did not fault us in any way as a committee. And I repeat, the Constitutional Court did not fault us in the way we handled the proceeding, not in any one particular instance. We are absolved. So we handle our matter in according with, one, the Constitution, the Administration of Parliament Act, the Powers and Privileges Act, and the Rules of Procedure. Strictly. So the issue about the powers of this committee are spelled out in Rule 175, and we shall proceed in accordance with that rule. So, having made that clarification, I think we are going to proceed.
The matter before you is a matter of abduction. Honorable Zaake rose in Parliament, I was there, talking about matters of abduction.
Chair, procedure.
No. Please. Let me listen to him.
And if you read the answer,
I like you colleagues to have very strong shock. This is a quasi-judicial. So let's listen to what the Honorable Patrick says, and we shall make the necessary decisions. Proceed.
yes, Mr. Chair.
Honorable Chair, but you made reference to the judgment of the Constitutional Court in respect to the matter of the Honorable Zaake against the House. And indeed, Chair,
In reference to only the committee.
the committee, yes.
Yes.
Yes, specifically on the issue of the committee. And well, I'm glad that I was the lawyer in that particular matter. And when we got that judgment, the lead judgment is very clear about the proceedings of this committee. Yes, like you have observed, they are quasi-judicial in nature. But the court pronounced itself on this matter in the lead judgment of Justice Mulyagonja that these proceedings are analogous to criminal proceedings in as far as the right to fair hearing is concerned. And in that particular judgment, Honorable Chair, they specifically quoted Article 28 and said in as much as it talks about criminal proceedings, it applies both in civil and criminal and as well as quasi-judicial proceedings like this one, the provisions of Article 28, the right to a fair hearing, which is non-derogable under Article 44. And one of such key elements of the right to a fair hearing is for the accused person, and I use this advisedly, or
Actually, there is no accused person here. We don't want what is not provided for under our rules.
okay, the person who is in quasi-judicial proceeding, our understanding of that particular judgment, the implication is that he's entitled to know the nature of the accusations against him. Just like the accused person has a right to know the nature of the offense being preferred against them. So in this one, the accused, the person who is under investigation, who is the subject of the proceedings, has got a right under Article 28 to know the nature of the accusation against him. That's why it's important to have it particularized that this is exactly that you did. And we have failed to get that, so that we can understand that. If I may conclude, the Honorable Chair, in response to what Honorable Isaac and Honorable Mutembule have said here.
But that I have already ruled.
No. Rule 175.
No, what I'm saying, that I've already ruled.
No.
I've guided on that.
No, on Rule 175, just seeking for guidance, Honorable Chair, with all due respect, about the specific sub-rule. Why it's important for us to know the specific sub-rule? The wordings are different. In sub-rule 1A, this committee has got powers to inquire into any complaint of contempt of parliament or breach of privilege or any matter of privilege which may be referred to it, and to recommend to the House. That is to inquire. Sub-rule A. The word is inquire. Sub-rule B, consider any matter of discipline referred to it by the Speaker or the House, including attendance of members of the and to report to the findings. The first one is to inquire. The other one is to consider. In my understanding, these two are different. The first one is inquiry. The second one is a hearing.
Hearing is your word.
Consider is hearing.
Yeah, no. Hearing is your word. And don't import that word into the rules. Our rules are deliberate. They use consider, and let us look at considering. Don't import words in the law.
Why I'm raising this, here, the Speaker said that as per Rule 175, I refer Honorable Zaake to the Committee on Rules, Privileges, and for disciplinary action. For disciplinary action. Now, the question we want to understand, is it a hearing against Honorable Zaake, or it's an inquiry generally about what transpired on that day? If that can be clarified, we shall be good to go.
It is both.
If it's both, Mr. Chair, if it's a hearing against Honorable Zaake.
And let me tell you, first of all, we were not in that house, and we don't know what happened. And we are not the one who are choosing. The matter was only referred to us, and we only read the answer as it is. 2, Counsel is reading the last paragraph, but when you look at that answer, it has almost like 1, 2, 3, 4, 5, 6, and you are looking at the conclusion. You are not looking at all what transpired before. And like you said, what you've read before, it's sit down, blah, 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 and so on, which we don't want to go into it because we have not found out. Let us look at the evidence before us because we don't know it. I repeat, we don't know the evidence. We are going to see that evidence at the same time you are going to see it. And we will put it for Honorable Zaake that in our view, this amounts to either a breach of Rule 175 A, B, C, D, or against our code of conduct. What do you have to say? And then the Honorable Zaake will have an opportunity. That's why we are not asking him to even start preparing a defense now. Just listen to it, cross-examine, and then thereafter we shall have an idea on the sort of conduct which is impugned by the House and referred to us. And that matter is now resolved. Let us do this. Let's proceed. Honorable colleagues, we did write to the Honorable Zaake on Honorable Zaake, I think you need it. I don't know that you'll speak through your lawyer, but on the 16th. And on the 16th, we forwarded to you whatever had been presented to us. I want you to confirm whether you received it. The communication on the 16th of December.
It's one of 7th December. We have it.
You received that communication?
It is here, yes.
Okay. And whatever these people who appeared before us brought to us, we forwarded to you. Is there anything which is mentioned in that letter which you are missing, which was not forwarded to you by the clerk? Whatever is mentioned in this letter, because that's what transpired in your absence. Colleague, that communication was forwarding to the Honorable Zaake what transpired when these technical people appeared before us. We forwarded everything to him and requested them to come, and if they want to cross-examine them, that's okay with us. We can schedule a date and you cross-examine them.
Thank you. We have item 1 up to 4.
Can we go it for purposes of the record?
Yeah, we have 1 up to 4.
That's the photo copy of the certified copy of the Hansard.
Yes.
A CD containing the video recording of plenary proceedings.
Yes.
A CD containing CCTV footages of the chamber.
Yes.
And a CCTV video analysis report on the alleged misconduct.
Yes, Mr. Chair.
Okay. And obviously, 1, 2, 3 following was to let the Honorable Zaake know how we are going to handle the matter. When you go to the next paragraph, 1, you are supposed to be granted an opportunity at appropriate time to cross-examine any witness you may wish to. 3, okay, that is overtaken by events because he has since then returned in the country. And then the other one was when we would reconvene. So if you've studied this, would you need to cross-examine any of the people who appeared before us?
Definitely would be interested in having those particular individuals cross-examined on the piece of evidence they tendered. But unfortunately, apart from the transcription, we do not have their testimonies, whether indeed actually they came as witnesses for purposes of giving evidence on oath or whatever. We do not have that record. We are not favored with the same.
We asked them to provide this because we thought they are the ones who have this as materials on the subject on the day that incident took place. So they just came for purposes of laying these documents to us. However, however you look at it, they are witnesses.
No, Mr. Chairman, what I was talking about, apart from what they tendered, we do not have their testimonies. What indeed they testified, we do not have it.
Clerk, can we, colleagues, you need to come in. Don't allow it. 2, the proceedings of that day, where these people submitted these documents. Okay? Forwarded to the lawyers, and do that by the close of business today.
May we also be advised as to whether, Mr. Chairman, there is any other witness on record who witnessed the proceedings on that day, not necessarily these ones who are tendering in a record, because this one is just tendering in the record which was in their custody. but any eyewitness who was there on that day so that we have them cross-examined?
You see, if they come, you'll be here, because every day you are going to attend all the proceedings except when it is report writing. So every witness who will come, you will see him and you will cross-examine him.
Finally,
yes.
Honorable Chair, considering the circumstances of this matter, like you have properly guided that this is an inquiry, should we go expecting the Speaker, the Deputy Speaker who presided over the proceedings on that day, to come and testify?
No, that will leave it to our discretion. We shall invite whoever we think is relevant to this.
Most of that.
If you want, you'll be a witness, and you know how to get your own witnesses. But our witnesses, we shall get whoever we think is relevant to this inquiry. We shall invite him, and once you invite him, you will cross-examine. Okay?
No, but Mr. Chair.
But if he's your witness, you can invite him.
In an inquiry, Mr. Chair, there are no partisan witnesses.
Which one?
In an inquiry, like you are guided, Mr. Chair, that this is an inquiry. There are no prosecution witnesses, no accused witnesses.
Yes.
All are witnesses of the committee.
That's true.
And I think it would be appropriate, Mr. Chair.
Take it tongue in cheek.
Yes?
Take it tongue in cheek.
It's not tongue in cheek, Mr. Chair.
I'm the one who has said it, and I'm the one telling you so. So the witnesses who would be invited, you will have opportunity to cross-examine them, and the discretion is on us to see who is the relevant witness. Okay?
What the Honorable Counsel is saying is that basically he would like to cross-examine everyone who was present in the house on the day.
He did say that. He did say that.
No, that he is not contented with the Hansard issues presented, the recordings, the Hansard. He's not ready with that. But he is trying to perpetrate that they should be at liberty to call any eyewitness, and eyewitness are those members who attended the sitting on that day. So is that what he's trying to perpetrate, that everyone is at his disposal?
All witnesses are our witnesses, okay? Forget the other joke I had made, and which he had picked on when I said if you want him, bring him as your witness. All witnesses are going to be witnesses of the committee, because that's the inquiry, okay? And any witness we bring, they will cross-examine him, okay?
If I may be on record on that in single words, Honorable Chair, we would like to see that person who is aggrieved by the conduct of the Honorable Zaake appear here and testify. The one who is making accusations against the Honorable Zaake, who is aggrieved by his conduct.
If it is the house, you would like the entire house here?
This is exactly the whole point.
Oh, no,
that
we don't work at
if
that.
If it is the entire house, the people come from the house and testify
Chair,
that they are aggrieved.
Chair, the House referred the matter to this committee. We are considering, and that's why we are saying that all the witnesses belong to us. Like the Chair has rightly guided, any witness that this committee feels is a proper witness in this matter will appear before us, and we shall have that witness give us information that he has or she has, and you will have the right to be cross-examination. But for us to begin imagining that we know who is aggrieved and who is not aggrieved, and therefore we bring the aggrieved person, Chair, I don't think as a committee we know anyone who is aggrieved. The matters are just before us for consideration.
Yes.
The only person we know that there is allegation against Honorable Zaake of disciplinary nature. Now we are investigating to establish whether actually there is any disciplinary issue. And that's what we are doing. So we may not need to call this one, the other one. In our view, whoever we feel is relevant for us to find out whether Honorable Zaake is culpable or not, will be called, in our view. And if we don't call the one you think would be the one to make the case for or against, that is to the advantage of counsel for the Honorable Zaake, in my view.
Okay, let's look at it taken in that chair and pronounces himself. It is no longer about the Speaker. It's about the House. I have been making rulings here, decisions. It's not about me. It's about this committee. And that's how parliamentary proceedings are conducted. Once a Speaker pronounces himself on behalf of the House, seated as a Speaker, it is about that House. And if members are not agreeable with that decision, the rules actually provide a contest of that ruling. It's all detailed out in our rules. Say, no, right honorable, what we don't agree with what you are saying, doesn't reflect our views. And there's a whole procedure how you can contest a ruling of a decision of the Speaker. So what is referred to us here, don't look at the person presiding over. It's no longer that. It is now the House that refers the matter here.
Thank you, Chair. My name is Frank Kabuye, MP for Kasanda South constituency.
But I don't want to make a ruling. And please, take note.
And I'm just seeking clarification.
Please, you know what the rules say. You know what the rules say.
Chair, I beg to be guided.
You know what the rules say, really. I don't want to cause embarrassment here, please.
Requesting for submission. Requesting for submission. You're requesting a submission. Yes, sir, you're requesting a submission.
Chair, I just request to...
Hold on, Bokawi. You don't know, you know what the rules say. And please don't allow me to be on record, please. I am a very senior member of Parliament. I always want to do things the correct way in accordance with the rules, but without causing unnecessary embarrassment. And I hope you realize why I was. Do you want to make a formal ruling? Okay, let it lie.
And any matter before you must be based on the rules provided. It implies that anybody accused of misconduct must be accused within the rules. And it would be proper to proceed knowing that the accused broke this rule of the House.
That is going to be our finding. You want us to make a finding now whether the accused broke a rule or not without hearing any evidence?
Chair.
Please.
Chair.
Honorable Samba, let's proceed. Why are we here? We are here to find out whether there was any rule breached or not.
Chair, you earlier guide with.
Can you now go back to the rule on which you are raising that point?
Chair,
hold on. The reference to the rule is under Rule 175. That was what referred to us.
And
175.
Chair, yeah, 175, Chair, is broad, and there is nowhere where they say that the accused broke this rule of the House.
Oh, come on.
At this level, before you start the investigations, you should know which rule the member before you
175.
broke. What does it say?
Whether
Tell this House what it says.
Been ruled upon, and let's proceed. And if there is any contestation about the ruling, you go back again to the rules. Okay? We can't go through it over and over again and so on. If there is any contestation about the chair's decision or ruling, you go back again to the rules. That's how we work, and that's how Parliament works. Wanted to raise a point. Next time, then you raise the point. Now, you have a handicap that I can't see you. Can I therefore guide Honorable Counsel? One, you need to study this. Do you need any of these people who presented to cross-examine them, and then we give you a date when you are ready? Okay?
Yes, as you earlier directed with their testimonies.
Yeah, with their testimony. Provide them by the close of business day, and I think we can resume on Wednesday. Okay? 11 o'clock. But make sure they receive them by close of business today. Okay? Yeah. And then we can resume 11 o'clock on Wednesday. No gentlemen, there is no ladies. Gentlemen, officers who provided this, please be ready 11 o'clock for cross-examination in case Counsel wishes to cross-examine any of you. Okay? Whoever presented this, you understand? All of you are here? Yes? Yeah, all of you, make sure you are here. It's purely what you would call analogous to what you would call in the other procedures. What do you call it? Okay. Wednesday, 11 o'clock. Not even expressing. Can we have, you are put to notes that the other one we are going to do it tomorrow. And we've already forwarded the documents you did. Honorable Zaake, you got it? And can we be on record whether Honorable Lukwago will still be your lawyer? So that next communication, we know we don't have to be sending it to you, then we send to the lawyer.
Yeah, Chair, the Honorable Arias Lukwago is my lawyer still in that matter.
Okay. Clerk, take note. Colleagues, the Honorable Arias Lukwago will be representing the Honorable Zaake in that matter too. So we are going to conference tomorrow about that particular case also. Okay? 11 o'clock. Any other issue, colleagues, you would like to raise? Do you have any other issue to raise? Good. There being no other issue to raise, we are adjourning this case to Wednesday, 11 o'clock. However, the matter regarding the second issue, which was referred to us, when was it? We are setting out all the preliminary points of law, whatever it is, tomorrow at 11. So we are going to meet tomorrow at 11. But can you remain behind after this meeting? The matter is adjourned. Thank you for coming, Honorable Zaake and Honorable Lukwago. Have a good afternoon.
Ekisooka mu mateeka toyinza gamba nti waliwo omusango gw'ovunaana omuntu ng'awo Honorable Zaake n'otayogera ani amuvunaana naki kyamuvunaana mu buwandiike. Era kitubadde twagala okumanya ani avunaana the Honorable Zaake. Mu biwandiiko byonna tebakyogera. Ne sipiika yennyini ku Hansard teyayogera musango gwavunaana Zaake. Twagala ebintu bibiri. Ani amuvunaana era amuvunaana musango ki? Deputy Speaker yakubiriza proceedings ezo eza 29 October 2022 yali the Honorable Tayebwa talina kyeyagamba nti gwe guno omusango Honorable Zaake gwazizza. Era ne wetwogerera olwaleero tewaliwo kye bagamba nti gwe wakola kino ne kino ne kino ne kino era kimenya etteeka lino ne lino ne lino ne lino. Ffe kye tulaba nga kimenya ssemateeka article ya 28 era gye bayogeddeko ne musango Honorable Zaake gwe wabidde Honorable Speaker Anita Among. Amugamba nti please proceedings bwe ziba zifaanana bwe ziti oba omusango ng'owuliriza bw'oti
oteekeddwa okugondera ebiragiro bya ssemateeka mu nnyingo eya 28. Kooti etaputa ssemateeka yakirambise bulungi nti proceedings zino eziri mu komiti eno zifaananako nezibeera mu kooti. Tojja kuleeta muntu omuteeke mu kaguli wali omugambe nti gwe tandika weewozeeko nga tumubuulidde nti omuvunaana kino era n'akuvunaana yoono. Kakati olwaleero kirabye nammwe lwatu nammwe mbabuuza ababaddewo bagambye ani complainant ani avunaana Zaake baga nti nabo tebamanyi. Tubabuuza musango kinti abagenda kunoonya balabe obaddaayira alina omusango gwe yazza. Ekyo tekiriiyo mu mateeka. Toyinza gamba nti oleeta omuntu n'omuteeka wali mu kaguli n'omuganda tunoonyereza oba olina omusango guwaza oba tewali. Tukubuuza wali wamuvunaana nti alina omusango gwe yazza teguliiwo. So naye mu wisdom ya Chair agambye kabamale okuleeta abajulizi balabe obaddala waliwo omusango. Katukome wano ku Lwokusatu tulabe kye bagamba naye nga ffe tulowooza nti omusango alikomye na wano. In fact kino kumala budde bwa Honorable Zaake, kumala budde bwa bamemba ba Parliament, kumala budde bwa ggwanga, kumala budde ku nsonga ezitalina makulu ne baleka enkulu. Kuba toyinza kugamba nti kati ogenda kunoonyereza oba Zaake yazza omusango oba teyazza nga waliwo abaawamba abantu abamu nga batuulana mu Parliament nga tosobola kubanoonyerezaako. Twogera ku kiwamba bantu. Olwaleero bamemba ba Parliament ng'Honorable Oshabe bwagambye bali bweru bwa house olw'okubanga waliwo abantu ababuzibwawo. Balina abaana baabwe, balina bakyala baabwe, balina abantu baabwe. Abaana baabwe basiba maziga, bakyala baabwe basiba maziga, abalala tebalina na malaalo we gali, abalala baafa. Kati mu nsonga eyo enkulu Parliament gye yali tutte, akakiiko katudde, resources z'eggwanga, bonna nga balabe bamemba ba Parliament kugamba nti Honorable Zaake bakyanoonya balabe oba ddala alina omusango we yazze. Naye we tutuukidde wano olwaleero nga kiri kiriya Chairman agambye ne bamemba nti Honorable Zaake nabo tebamanyi musango gwe yazze, nabo balinze kuwulira. Katulinde ku Lwokusatu oba mukulu Deputy Speaker Honorable Tayebwa anajja agambe nti Honorable Zaake wazza omusango guno ne guno. Ffe gwe tulinze, ekyo njagala obbakakasa, tulinze Tayebwa ajje ku Lwokusatu abitebye agambe nti omusango guno ne guno ne guno, olwo Zaake asobola okunnyonnyola. Naye nga tannaba kujja ku mmeeza wali bino bamala nga tannajja mu kakiiko wano bamala budde. Ntu apiiru yagiteekayo kituufu naye luvannyuma ffe lwakutandika kulaba nga twenforcinga ruling owa judgment ya Constitutional Court ne batandika okusattira. Omanyi kye bayita an afterthought, era baagala okudireyinga okola kino ne kino ne kiri. Naye nga twabagamba notice of intention to sue, notice of intention to appeal tetegeeza nti olwo judgment ya court evuddewo. Era kyovudde olaba ne Honorable Katuntu akyakootinga judgment tebagiyimiriza. Twaliyagadde bagigondere nga Honorable Katuntu wano Chair bwagikwotinze ne Kiraka ne Speaker nabo bagigondere Honorable Zaake adde mu office ye ya commissioner. Eri luddawo bagirage court order nti ye neyimiriza. Teriiyo tebakulimba. Wetwogerera bakyakukuta basabe state of execution bakyakukuta bukukusi naye tebagirinaayo teriiyo. So bw'oba tonnafuna state of execution gondera ekiragiro kya kooti. Tuyinza kubanga gwe Parliament mu nnyingo ey'ensanvu eya ssemateeka nga kikkakatako okukuuma ssemateeka butiribiri ate nga gwamuyisaamu olugaayo kyabulabe nnyo eri eggwanga.
Okusookera ddala mukimanyi nti omusango guno gwali kankiite gwadiba. Ensonga eno yali yadiba olw'ensonga nti twababuuza ebibuuzo balabe bange babuuza ebibuuzo batasobola kuddamu era nga bitubuuziza olwaleero. Kiki nakola baani abanvunaana ebintu ebyo tebabirina era omusango gubadde gwadiba. Kino ekintu kya Novemba omwaka oguwedde kye twogerako si mwaka guno naye tuli mu Novemba kati. So kiba kitegeeza nti waliwo akakuku wakati wa Parliament eno ke banninako nange nti waliwo personal issues eziriwo ze bata-addressing ze batayagala kuvaayo kubuulira ggwanga naye ng'esinga ddala obukulu bano abantu twabawangula mu kooti. Obusungu balina bungi nnyo tebaagala mbeere wano ng'ate nina okubeera wano nga parliamentary commissioner kati balina okunnwana mu mbeera yonna. Kino kiri clear nti eno persecution eri clear nnyo n'ensonga endala nti ensonga ze naliko zaali za kuwamba bantu baffe. Y'ensonga enkulu. Tulina business egenda mu maaso tewaliwo kyebogera mu parliament wali kigenda mu maaso olw'ensonga z'okuwamba abantu baffe kati balowoozezo kikomyawo balowooze nti bajja zikiza opposition yonna eri mu parliament nga bazze wano okunkolako mob justice era endala nga bwe baginkolako ku mulundi guli eri so tebalina nsonga yonna wabula okuleka okumbonyabonya mu mbeera yonna naye bakimanye nti nze ndi strong nze ndi mugumu nze najja mpanise nga mmanyi nti kino kyenzijidde nga nkyetegekedde ekijja kijje tulina kubazoganya paka we banatuwa abantu baffe ate paka Museveni wanatuviira. Yeah, it is very clear that these proceedings had stalled from last year November. They had no way how they had to proceed with this case. Reason being, we asked different questions that they could not answer. We wrote to them. Actually, one member has been alleging that we never wrote to the committee asking for the preliminary questions. My lawyers asked them different questions. Who is alleging that I did ABCD? And what is that ABCD? What are they having against me? So it is very, very clear that these people have all the annoyance as to why I won them in court, in the constitutional court. They are very annoyed because they don't follow the law. Parliament itself that enacts the laws, it doesn't follow them. So they are annoyed. So there is something that is very personal with the leadership of this parliament, with me as a person. So it's the reason as to why even right now, parliament is not proceeding in any way because of the reasons of the abductions of our people. So those demands that we want this government to free our people is the reason as to why now this matter is back so that they put the opposition down. We stop asking those hard questions that they can't answer. But we are telling them that for us, we are ready for you. We shall not go down. We shall not get down till when those questions are answered. We shall keep on asking those hard questions till when the government is down.